All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please place the matter on the record.
Good afternoon, Mr. President. Situation in Libya in the case of the prosecutor versus Saif al-Islam Gaddafi, case reference ICC 0111-0111, and for the record, we are in open session.
Thank you very much. Appearances, please, from the defense side.
Good afternoon, Your Honour, Mr. President. Lead Counsel SFR asked me to convey his apologies and regrets that he cannot attend this afternoon. Your Honour, Mr. Gaddafi is represented by Khalid El Zaidi, Kamis Al Zanetti, Libyan law advisors, and I'm Aidan Ellis, counsel.
Thank you very much.
Good afternoon, Your Honour. Appearing for the prosecution is myself, Helen Brady, Senior Appeals Counsel. I'm here today with Ms. Marichal Regay, Appeals Counsel, Ms. Alison Whitford, Associate Trial Lawyer. Behind me, Mr. Julian Nichols, Senior Trial Lawyer. Next to him, Ms. Nevada Theroux, Associate Appeals Counsel, and our case manager, Ms. Biljana Popova. Thank you.
Thank you very much.
Good afternoon, Mr. President. Victims in these proceedings are represented by the Office of Public Counsel for Victims. Appearing with me today, Ms. Sarah Pellet, Counsel, Ms. Anne Grabowski, Legal Officer, and I am Paulina Massidda, Principal Counsel.
Thank you.
Thank you, Mr. President. Narek Swanson van Hooydonk on behalf of Lawyers for Justice in Libya. Next to me is Ms. Alejandra Vicente on behalf of Redress.
Thank you very much. And for the record, the representatives of the government of Libya are not in attendance today. I understand there's another appearance to be made.
Je suis Lamar Abdessalam. Je représente le Conseil suprême.
I am representing the Supreme Council of Libyan Cities and Tribes, Amamara Ali Abdusalaf Atef Said.
Thank you very much. We are convened today for the Appeals Chamber's judgment in the appeal of Mr. Saif al-Islam Gaddafi against the decision of Pre-Trial Chamber 1 dated the 5th of April 2019 and titled, quote, Decision on the Admissibility Challenge by Dr. Saif al-Islam Gaddafi pursuant to Article 17 1C, 19 and 23 of the Rome Statute, unquote. This is the summary of the judgment. As always, it is important to keep in mind that this is only a summary of the judgment conveyed in a formal language that will be more accessible to the public. Consequently, the formal language used in the summary are often different from the formal language used in the actual judgment. For that and other reasons, this summary is not an authoritative document. The authoritative document is the written judgment, which will be made available on the website of the court soon after this session. On the 26th of February 2011, the United Nations Security Council referred to the ICC prosecutor the situation in Libya, covering the period dating back to the 15th of February 2011. Following that referral, the pre-trial chamber issued a warrant of arrest for Mr. Saif al-Islam Gaddafi on the 27th of June 2011 for the crimes of murder and persecution as crimes against humanity. The allegations relate to suspected attack by Libyan security forces against the civilian population taking part in demonstrations against the regime of Mr. Saif Gaddafi's father, Muammar Gaddafi, or against those perceived to be dissidents of that regime. These alleged attacks apparently occurred during the period from the 15th of February 2011 to the 28th of February 2011 at least. Mr. Saif Gaddafi, whom we shall refer to as Mr. Gaddafi throughout this judgment, is alleged to be criminally responsible as an accomplice for the commission of the crimes indicated in the warrant of arrest, for reasons that include his senior leadership role in the Libyan state apparatus and for being part of the inner circle of his father's regime. On the 4th of July 2011, the registrar of the court made a request to Libya to arrest Mr. Gaddafi and surrender him to the court. About 4 months later, by a letter dated the 23rd of November 2011, the National Transitional Council of Libya confirmed that Mr. Gaddafi was arrested in Libya 4 days earlier on the 19th of November 2011. But Mr. Gaddafi was not transferred to the ICC as the registrar had requested. Instead, the relevant authorities in Libya launched a challenge to the admissibility of the case at the ICC. It helps to recall that a challenge to admissibility is an objection saying that the Rome Statute does not allow the ICC to take up the case in question. In this case, Libya's admissibility challenge was mounted on grounds that the relevant authorities in Libya were handling the case. That being so, the ICC's cardinal doctrine of complementarity being a condition for ICC's exercise of jurisdiction under the Rome Statute requires the ICC to defer to the proceedings in Libya. The record of the proceedings at the time clearly shows submissions made on behalf of Mr. Gaddafi to the effect of saying that he was in favor of dismissing Libya's admissibility challenge and preferring a trial at the ICC instead of in Libya. Although during the hearing in this particular appeal, a different set of defense counsel for Mr. Gaddafi denied that those earlier representations had been made on the instructions of Mr. Gaddafi at that time. On the 31st of May 2013, the pre-trial chamber dismissed Libya's admissibility challenge. That decision was later confirmed by the appeals chamber on the 21st of May 2014. That notwithstanding, Mr. Gaddafi was still not transferred to the ICC. In the meantime, criminal proceedings were conducted against him in Libya. Eventually, about 5 years later, on the 6th of June 2018, Mr. Gaddafi filed a challenge of his own to the admissibility of his case at the ICC. His reasons were, first, that as of that date, he had already been tried, convicted, and sentenced by a Libyan court sitting in Tripoli for substantially the same conduct as alleged in the proceedings before the ICC. That being so, the Rome Statute forbids yet another trial at the ICC. He argued additionally that he had subsequently been granted an amnesty by the Libyan authorities on the basis of a certain piece of Libyan legislation passed in 2015 called Law Number 6, and was for that reason released from prison on or around the 12th of April 2016. He argued that the ICC must respect that amnesty. On the 5th of April 2019, the pre-trial chamber dismissed that admissibility challenge from Mr. Gaddafi. That decision is the subject of this appeal. Mr. Gaddafi's appeal was argued on two grounds. Under the first ground, it was argued that the pre-trial chamber erred in law in deciding that the provisions of the Rome Statute, which forbids prosecuting someone again at the ICC if that person has already been prosecuted elsewhere, may apply only if the earlier judgment had become truly final in the eyes of the law. This issue is important because of two considerations. First, is that there is a question whether Mr. Gaddafi's trial in Libya was conducted in his absence. If so, Libyan law, as it was canvassed before us, requires that a person tried in his or her absence will be retried whenever he or she finally turns up within that domestic judicial system. So if it was really the case that Mr. Gaddafi was tried in his absence and that trial could be redone at a later time, it means that the judgment of the first trial is only a provisional judgment, so to speak, and not a final judgment. The second consideration is that the issue concerning the issue of finality of judgment was engaged in the appeal because the penalty imposed upon him at the conclusion of his trial in Libya was the death penalty. Under Libyan law, as canvassed before us, all death penalty judgments must undergo a review by the Court of Cassation. That is the final appellate court that handles criminal matters. That cassation review has not been done in the case of Mr. Gaddafi. And that is a further reason to see the judgment of the Libyan court as a provisional judgment and not a final judgment. In the circumstances, the pre-trial chamber held that Mr. Gaddafi's trial in Libya was not final for the two reasons outlined above. Those being, one, Mr. Gaddafi was tried in his absence, thus meaning that his trial may have to be redone in future. And two, his sentence of death has not been reviewed by the Court of Cassation. The sum of the pre-trial chamber's decision is this. As long as the judgment in Libya was not final for any or both of those two reasons, the case of Mr. Gaddafi is not forbidden for prosecution at the ICC. That is to say, using the double negative formulation, the case is not inadmissible at the ICC. Therefore, Mr. Gaddafi's admissibility challenge must fail. Counsel for Mr. Gaddafi argued that the pre-trial chamber was wrong. According to counsel, no such finality is required as a matter of law for the earlier judgment before a subsequent trial is forbidden at the ICC. According to them, it is enough that the earlier domestic trial proceedings, even at the first level of the courts, concluded with a verdict on the merits. For reasons fully laid out in the judgment, the appeals chamber rejects the arguments made on behalf of Mr. Gaddafi as to this ground of appeal. The appeal chamber holds that the pre-trial chamber did not commit an error in finding that the judgment on the earlier occasion must be the final judgment before it can bar subsequent proceedings at the ICC on grounds that the same case has already been tried elsewhere before. The reason for the appeals chamber's holding in this regard include this consideration, but not the only one. The jurisdiction of the ICC is complementary on the contingency that the earlier case was not conducted genuinely. It is good practice to withhold concerns about the genuineness of earlier proceedings at the national level in order to see what that system does as a whole. It is possible that the appellate process in the domestic system is able to correct any errors at a first instance trial, errors that might raise concerns about genuineness of the trial at first instance. Conversely, it is possible that the lack of genuineness of the judicial process can occur at the appellate level in a way that negates a first instance trial that was conducted genuinely. In the circumstances, it becomes important to require finality for the national proceedings before deciding that those proceedings were enough to bar a case being tried at the ICC. Under Mr. Gaddafi's second ground of appeal, it was argued on his behalf that even if finality of the domestic proceedings were required, such finality was effectively achieved in respect of Mr. Gaddafi's trial in Libya. As it was argued, this was because Law Number 6 granted him amnesty. By that grant of amnesty, the Libyan proceedings against him became final for all intents and purposes. It was argued on behalf of Mr. Gaddafi that the pre-trial chamber erred by failing to see things that way. It is important to note that the pre-trial chamber found that Law Number 6 did not apply to Mr. Gaddafi. On appeal, Mr. Gaddafi's counsel raised several arguments of a highly technical nature to challenge the pre-trial chamber's findings on this ground. Having considered all those arguments, the appeals chamber is not persuaded that the pre-trial chamber committed an error. The appeals chamber's reasoning in this regard includes, but is not limited to, the following considerations. Counsel for Mr. Gaddafi submitted that the pre-trial chamber erred when it found that he had been charged with crimes amounting to identity-based murder. That category of crimes is excluded from the amnesty. His counsel puts forward arguments as to how the term identity-based murder should be interpreted. However, counsel has not provided any authority in Libyan law to support this interpretation, such as to contradict the pre-trial chamber's understanding of the term. The appeals chamber also notes that the pre-trial chamber stated that its finding was consistent with the Libyan government's position that Law Number 6 did not apply to Mr. Gaddafi. Furthermore, in that regard, there is no information in the appeals chamber's finding tending to show that Mr. Gaddafi rendered the apology that the Law Number 6 requires of those wishing to claim amnesty offered under that law. As well, there is no information tending to show that Mr. Gaddafi made any pledge of repentance and to not reoffend, nor is there any information tending to show any effort on Mr. Gaddafi's part to reconcile with victims. All these appear as necessary conditions before the offered amnesty can avail anyone, according to Article 2 of Law Number 6. As part of his argument that he benefited from the amnesty under Law Number 6, it was contended that Mr. Gaddafi's release from prison was evidence of that benefit. But the appeals chamber finds that there is no clarity from the information and submissions before the appeals chamber, which authoritatively explains the basis on which Mr. Gaddafi was released from prison. It is noted in particular that there is no evidence of a reasoned decision from the competent judicial authority certifying his benefit of the amnesty. According to law number 6, in Article 6, such a written decision is an apparent requirement of law number 6 for purposes of the amnesty offered. It may be noted in this respect that Libya was at all material times a country going through a difficult transition phase in which different armed factions controlled different parts of the country. Some confusion must be assumed in certain respects. It is notable that Libyan authorities have repeatedly averred, including more recently before the appeals chamber, that law number 6 does not apply to Mr. Gaddafi. In that regard, the appeals chamber took other considerations that the pre-trial chamber took into account in reaching its decision. Accordingly, the appeals chamber concludes that the pre-trial chamber did not err when it found that the case against Mr. Gaddafi is not inadmissible before the court. In the outcome, the appeals chamber unanimously rejects the appeal lodged by Mr. Gaddafi and confirms the decision of the pre-trial chamber. This brings us to the end of the summary of the appeals chamber's judgment. Once more, it is stressed that this summary is not an authoritative document. It is intended only to convey the essence of the appeals chamber's judgment. The authoritative pronouncements of the judges are those contained in the written judgment, which will be filed after this hearing. I and Judge Bosa jointly append a concurring separate opinion to this judgment. Judge Ibanez Carranza will in due course file a concurring separate opinion to this judgment. Both separate opinions were merely for judges concerned to make certain points they consider important and interesting to make, in this case concerning the question of amnesty, how that is to interact with the complementary regime, and also how that has been treated under international law. These opinions separate do not take away from the unanimity of the appeals chamber's finding on the main judgment. Finally, I wish to thank all court staff for their assistance in facilitating today's hearing. The hearing is now adjourned. Thank you very much.
All rise. We will obey.